Good morning, good morning, good morning. How do, how do? Come on in, man. It's time for the next lesson. All right. What we're going to talk about today is the 40 rector experience. It's incredible. It's incredible. So let's start with your union grievance coordinator and their fiduciary and how they supposed to basically represent you. If you don't understand what I'm saying, drop down Black's Law Dictionary app. That's one of the best things you can do to help you. In Black's Law Dictionary app, look up fiduciary and see what it says. Okay? It's going to have the fiduciary duty, the fiduciary responsibilities, the fiduciary relationship. These are all the things that covers representation of a person. You're going to see that too, under representation of a person. Under your signed contract agreement, okay, that would come with the collective bargaining agreement. Okay, so let's move forward to Mr. Attorney. How would you say, Mr. Esquire? Yeah, he signs his name Esquire. Okay, understand that. Uh, like they say, most lawyers, or the good number of lawyers in New York, sign Esquire. Not a problem. Not a problem. You want to sign Esquire? Let's stick to those canons. So, and judicial code of conduct. So, on the day in question, when we went to 40 Rector, I got there before he did. And let's just say the officer got there before he did. And then shortly after, the employer administration and attorney showed up. Shortly after that, the union grievance coordinator shows up. Now, once you come in at 40 Rector, you basically have to sign in, state your cause and reason for the day, and they direct you on where you're going to be at for the day. So, this individual comes in, states his name, his organization, his purpose for being there, signs off, and it's a beeline straight to the employer's attorney. And as he's walking up to her, he's telling her, you have this. You got this one. You got this one. You have this. We didn't even get into court, and you're saying this? Fabulous. No, what makes it truly fabulous is that this action offended the receptionist who got up, seen what was going on, looked at the officer, and then looked at his representation and what his representation was saying to the employer and the employer's lawyer. So the receptionist knew that this was illegal procedures, and not to just say illegal procedures, but deceptive practices possibly going on. So she got up, came out from her station, walked around, went up to the grievance corner, addressed him, and said, "Sir, your client is standing over there watching you. You need to go over there with your client." Let's just say, when he came over, the officer was standing there just looking at him. Now he's got the shy face, like you caught me, but you don't know what I know. Okay. When we go into court, well, prior to going to court, we go into the interview room. He was given a letter that was given to the officer. And He was basically more trying to get into confrontation with the officer instead of working for the officer. Because he wanted the letter, the officer's like, I want the letter back, that's for my record. Long story short, he should have never gave it to the attorney. Should have never gave it to the grievance coordinator. That was the end of that letter. When you try to get it back, you can't get a hold of him. It's always a story. When we go into court, under the Judicial Code of Conduct, Part 1200, New York State. All right, it's basically this. It basically says what a lawyer and how a lawyer is supposed to operate within the judicial system, within a tribunal. So in this tribunal, we're gonna go down to what was that? On the Judicial Code of Conduct, it's gonna go down to 3.3. 3.3 basically tells you what you're supposed to do in the tribunal, how you're supposed to be. Then we're going to go down to 4.1. 4.1 states that the lawyer must be truthful. Okay? He must be truthful. Okay? Then let's move forward to 8.3. 8.3 covers the fact that if the plaintiff, which is the employer, and their attorney, there's such thing as called clean hands. Okay? Their documents must not be fraudulent in any way. No, not one bit of fraud. Now, if anything that's fraudulent that's being presented as evidence to this case, the grievance coordinator who identifies this is supposed to let the court and the judge know that the evidence that's being submitted by the plaintiff is fraudulent. It constitutes an impropriety, a wrongdoing, a crime, a felony, a misdemeanor, an illegality. Okay? He's obligated to report this. That's on the 8.3. Okay? Reporting misconduct by the opposing attorney. Failure to do so brings about 8.4. It comes on your trustworthiness, your honesty, your fitness as an attorney. So since he failed to do that, we move up to, I think it's 8.5, where it must be reported with the Judicial Committee, and they do their hearing. Because such grounds can possibly be cause for disbarment based on the fact of how they know and how much they know. Because the fact of the judicial misconduct constitutes under subsection 4 judicial conduct 487. Okay, misconduct by an attorney is a Class A misdemeanor. Okay, it's Class A misdemeanor. So, based on the fact that he known or reason to believe is known not to violate his canons, which under canons 9, lawyers are to avoid improprieties or even the appearance of an impropriety. The mere fact that the sergeant submitted a document that stated that She called at 11:45 and gave the order. The officer was not on the clock at 11:45 under signed contract agreement. The sergeant did not put the officer on duty. The sergeant did not send transportation to pick the officer up. The officer was scheduled to report to that location. Location A. The sergeant wanted the officer to come to location B without transportation. Try to use a bully game. Said actions in doing so, giving such a order to make the officer comply while the officer's off duty, constitutes intimidation under the corporate compliance policy. Under that, intimidation brings about threat and coercion, 135.60, where you're going to use number 8 under your job, in your position, which brings about abuse of powers, where you're going to use your leverage because of your position to oppress someone. Said actions to do so would constitute Class A misdemeanor. Do your research. Do your research. So, you didn't send transportation, right? No. Where's the act of insubordination? This is what the lawyer was supposed to argue, but he failed to argue that. So he just went along with the ball game. So since the impropriety is there, once she stated that the impropriety was there, that part of that charge is now thrown out. It does state, if you can prove that the charges was fraudulent, or they didn't have a true charge, or if you could prove that they violated any part of due process under your 5th and 14th Amendment, under your substantive and substantial right, everything is vetoed. It is automatically tossed out. I say it to you once, I say it to you again. A court is a ship as well as a bank. Okay? I want you to understand. A court is a ship as well as a bank. The document submitted to court to have it function is basically the affidavit, which is a manifest. If anything is fraudulent on that manifest, we cannot conduct trade under maritime law, or the law of the sea, the law of currency. Get it? It's not very hard. So, since your actions was all fraudulent, and that document was fraudulent, a contract in void is fraud. The ship cannot sail because you already torpedoed it. It's sinking while it's docked. It's sinking. They don't even have to go out to sea. It's already sinking. And this is by your actions. So you can get all the clay dough that you want to do and that love your documents. I have all your documents and I'm hanging you on your documents. There would be no hearsay. It'd be just your documents. Why? Because as per your documents, in closing, ready? The facts cannot be altered or denied. You have a wonderful day. And I'm out. Peace.